depending on where you are. Welcome to the Phia Group's October webinar. I'm your host, Adam Russo, and I'm very excited to be here today. Today, I'm actually not at the office. I'm not at our headquarters, our beautiful, shiny building. I'm sitting in the basement of my home. It's very dark and dreary down here, but it's very similar to what Ron experiences on a daily basis. But today, based on that dreary, theme, we're going to talk about new opportunities to save, create revenue, and avoid scary practices. We're out 10 days away from Halloween. I'm not sure about you, but my 4 kids definitely have costumes. They definitely want to go trick-or-treating. So I might go to jail for it, but we're going to see what we can pull off. So what are we going to talk about today, folks? We're going to talk about the PGC's FAQs. It's not going to be with who you expect. The 2020 election update, we will make sure that Brady is not involved in that. The Supreme Court nomination, what it means for healthcare. Again, we're going to try to have Ron or somebody else talk instead of Brady. I'm only kidding. Case studies, trick or treat. And last but not least, political update. Now, when we talk about case studies, folks, we actually have scenarios that are real, that have happened at Phia, that are extremely scary. And we try to then show you what we've did and then what you could do to ensure that those things don't happen to you again. Next slide. So here are our speakers. There's the good-looking guy on the left. That's me. I am the co-founder and CEO of this fine company. And with me, as always, is the amazing Ron E. Peck. Say hello, Ron.
Hello, Ron.
Really, Ron? That was pretty weak. Can we
well,
do it again?
I'm in my dreary basement, Adam. So I don't want to wake up the rats.
Well, be a little excited, man. I mean, it's a big deal. Today's a webinar. We had a lot of people on this call. It's exciting. Come on, man. In addition, In addition, we have the director of the Legal Compliance and Regulatory Affairs at Phia. Say hello to Brady C. Bizzarro. Say hello, Brady.
Hello, Brady.
All right, that was a little weird. Ron, do you agree? It's getting worse. Folks,
Yeah,
we apologize. It's getting a little bit worse. Now,
I think he just woke up.
Yeah, he definitely just woke up. Well, he's on the afternoon shift, right? Or the 3 to 11 shift, I guess. Now, if you notice, Jen McCormick is not here. And there is a reason for it. She was fired. We apologize for that, but she was let go from Phia. She just wasn't working out. Right, Ron?
Literally, the count just dropped. Everybody hung up the phone.
That's the scary part. Is the minute you tell people that Jen's not around, people just hang up. No, folks, Jen, can we say it, Ron? Can we tell people? Is that a HIPAA violation?
Let's just say she's out of the office, but it's good news.
Really good news. Can we say there was an addition to the family? Is that allowed? I don't know. I mean, I assume it's okay.
I think a future Fian on the way. Absolutely.
There is definitely a future Fian on the way. If you want to email Jen and congratulate her, she's hopefully going to be coming back pretty soon. I actually think she's coming back too soon, but she just wants to come back to the company. But no, guys, J-Mac had a baby, and we're very happy for her. The baby's very healthy. And in her place, it's a major drop-off, let's be honest. But in her place is Kelly Dempsey. Say hello, Kelly.
Hello.
All right, come on. Jen has the right to not say hello, Jen. But you should be saying hello, Kelly. I'm just saying. Well, that's all I gotta say.
If I'm substituting for Jen, I have to act like Jen. So
that's true. And I was only kidding about that. You're not a far drop off. She's like an A. You're like an A minus. How's that? Is that okay to say?
Acceptable.
All right, good. I'm just kidding. Next slide, Matt. So as always, please email us at pgcreferral@phiagroup.com with any and all of your questions related to COVID or anything else. As you all know, we have 3,000 plus requests a month just on anything from a claim exclusion issue to a COVID-related issue, plan document, whatever it might be. Feel free to reach out to us, and we'll do our best to help you out. As always, please follow us on LinkedIn. Matt, I think we have, 5,050 followers now on Phia? Something like that? I'm not exactly sure, but it's in that range. To get the latest, greatest news. How much is it?
5,022, and hopefully that'll go up after this webinar.
So if you're not following us on LinkedIn, please do so either during this webinar or right after. Just go to LinkedIn, search for the words The Phia Group, and I guess every day we have new stories. Either we share stories that we found, or there are our own unique stories of just things that we're doing and seeing in the industry. And before people ask, all of these slides, the recording of the slides, all of it will be available on our website at www.fiagroup.com. And also, please download our podcast, listen to us on Apple or Google Podcasts. We do a couple every week. They're really fun. They're very interesting. And again, it's tied to specific issues related to our industry. So we thank all of you who do that and come on and listen to us every single week, every single month on these webinars as well. And as always, a special shout out to, I can't get this last name, Denise Kasner, I assume, the Senior Clinical Management Specialist at True North Companies. Now, guys, I read this, what Denise told us. I mean, can someone explain what she was talking about here? I know that she's the youngest of 8 kids from an Iowa farm. I'm assuming that everyone had to work on the farm because there were no child labor laws. And once the baby, is she now 56? Is that what she's saying? Called another B word? Gotcha. Ron, please help me out here. What is this?
I think that's an accurate interpretation, and unless somebody says otherwise, we're going to go with it.
I mean, I'm almost thinking that we shouldn't send Denise a package because this whole what she told us piece is very confusing to me. But anyways, Denise, I'm only kidding. Thank you so much for listening. Matt's going to send you a bunch of goodies. I'm not sure what it is. I don't want to tell you what it is because the minute I say that you're getting a t-shirt, 100 people are going to be wondering why they didn't get t-shirts. But again, Denise, thanks so much for listening and being a loyal follower of the Phia Group podcast. Next slide. Phia Group webinar and podcast, sorry. Next, subrogation value reports. Folks, as you know, these value reports are amazing. All of our clients get them. We've now added 2 new value reports to the mix. The first being the balanced billing value reports. So any of our clients who utilize us for balanced billing support and defense as it relates to their reference-based pricing claims or issues, you get these reports. And last but not least, the Unwrapped value report. For those of you who do utilize our Unwrapped service, you're well aware of the fact that it replaces your wrap networks, offers you significant discounts above and beyond what the typical wrap network discounts are. And we're very proud and excited to share these value reports with all of our current and future clients as well. Now, guess who's going to be sending you these reports? It is the Phia Client Success Team. Our success team is made up of Tim, Rebecca, Michael, and Krista. They are currently reaching out to all of you, to our clients and prospects in regards to how things are going, what's not working, that's the most important thing for us, and what we could do in the future to assist and support you to ensure that we're doing everything possible to reduce the overall cost of your clients' healthcare claims while ensuring the best and highest quality service as well. All right, so for the first time, Kelly Dempsey, I hope you're up to the challenge. It's on you. Last month's PGC FAQs.
Thank you, Adam. It's definitely not the first time, but it's been a while since I've had to make my cameo. I think the last time was probably on Jen's last maternity leave. So with that, the
last maternity leave. That's the last time?
Yeah, probably.
I'm thinking we need people to reach out to us and see if, based on your performance today, whether we should try to stop bringing you in, not just when Jen's out taking care of a new child.
All right, well, I guess I'll make myself up to that challenge. All right, so first question that we have definitely covered this topic before, but claims are obviously rolling in related to COVID-19, so it's relevant and coming up, so we wanted to talk about it again. But the first question is that TPAs are getting claims for the COVID-19 mixed with other claims which appear to be unrelated to COVID-19. So which claims have to be covered at 100% without medical management requirements? So our interpretation of the Families First Coronavirus Response Act is that when the prohibition on cost sharing applies, is specifically related to service items that are regarding the furnishing the test or administration of the test or the evaluation of the individual's need for a test. So providers obviously determine medical necessity, but they will also potentially order a variation of tests to determine what is happening. So there might be a flu test, a CAT scan, maybe some blood tests. Obviously, coronavirus has a lot of varying symptoms that cross over to other medical issues. So multiple tests might be needed to determine whether or not a COVID-19 test is required. So that is the first kind of piece of it. So based on our interpretation of these laws, the payer's obligation to pay a posted cash price applies actually to the test as well as the charges related to the administration of the test. But the problem is that the provider's obligations are only required to post the cash price of the test. So this actually could be good news because plans have a little bit of potential wiggle room to negotiate the other services if there's no posted cash price. So, you know, for right now, that's what's happening. That's what's standing in that specific situation. Of course, it's always subject to change. But when there are questions related to the coding concerns under the different laws that we have here about what is a medical management requirement and what is not, typically medical management requirements are specifically your pre-authorization, requirements related to medical necessity, and then anything experimental investigational. So those are the things that are prohibited in the COVID-19 space with the testing. But we do believe that claims are still able to be reviewed for potential fraud and improper billing. I know there has been some articles on different news sources that talk about the various and vast array of billing that we've seen for some of these COVID-19 testing, depending on where the test is being administered. So it's definitely still okay in our interpretation to do that look from a fraud perspective. So again, these questions are coming in hot and heavy. We're happy to help. Hopefully this information is helpful. And with that, we can go to the next FAQ.
Hey, Kelly, before you move on to the next issue, just on that COVID piece. So you mentioned the whole fraud, being able to actually investigate the claims for fraud, et cetera. So folks, if you are actually a client of Phia's and you actually send us over your claims data, that's already being done for you. We're scrubbing all the claims in addition to all COVID related claims to make sure that everything, you know, looks the way it should look. There's nothing there that looks like it should be, you know, it was overcharged or overpaid, or that someone else may be responsible for paying it. So it is part of our normal daily scrub. So
good to know. So our next question is actually kind of takes us back in time a little bit, but there is some recent questions about stop loss policy imposing dollar limits on transplant benefits and whether or not the SPD can mirror the stop loss policy. The short answer is no, not really. Transplants are generally considered an essential health benefit under the ACA, and the ACA has obviously put a prohibition on annual and lifetime dollar limits on any essential health benefit. So that generally falls, the actual transplant would fall under that specifically, as well as potentially any prescription drugs that might be, offered in conjunction with that transplant. The catch here is that sometimes travel and lodging is a covered benefit under the health plan, and that piece may or may not be an essential health benefit. It just depends on what benchmark specific plan is using. So a quick reminder that self-funded plans have the ability to use any of the benchmarks that are out there. Doesn't matter based on where they are located, where the employees are located. The goal is to pick a benchmark that aligns with the benefits that you are offering. So travel and lodging potentially can have a dollar limit, but the actual transplant cannot. So sometimes plans don't realize that stop loss has limits on these things. So we obviously highly encourage all plans to review their stop loss policies in detail with a fine-tooth comb. The reason why stop loss is not subject to the ACA dollar limits is because stop loss is not actually health coverage. It is financial insurance for employers. So it's not regulated by the ACA or ERISA or other federal laws that our health plans are related to. And instead it's governed by state law, but it's not considered health insurance. So that one is quick and easy and takes us back in time a little bit, but it's still very relevant because we do see these dollar limits appearing from time to time on policies. And with that, I will turn it over to, dare I say, Brady?
That's right. That's me. Look, I'm excited for this webinar because it's our last webinar before one of the most important elections of our lifetimes. And I can say that again. We said it 4 years ago. But it's true for us. It's true for healthcare especially. And as our listeners will see throughout, we've kind of mixed up the political update here throughout this presentation. But it's important for us to go over the election preview because, like I said, it's our last chance. So it may feel like deja vu, right? We've got the polls all showing that Joe Biden has a significant double-digit lead over President Trump. We saw this last time. There are really only about 14 states that matter in this election. I've highlighted the ones for you to watch if you're watching on election night, like I will be, to see what happens with these states. It looks like, looking at the polls that are out there now, most people put Biden's chances. I saw one saying 87 out of 100 times he wins. So that's looking pretty good for him, but you never know. We'll have to wait and see. The top issues, though, as we know, are COVID-19, healthcare, and the economy. Those last two are always coming up as the top two, but obviously COVID-19 is still lingering around and affecting all of us, including us in the employer-sponsored health insurance industry. And so what is at stake for us? What are we concerned about in this election? What will matter? What will change depending on who wins? We put a little table here just highlighting the top positions of both candidates so that we know what to expect. We know, obviously, that President Trump has expressed a position to repeal and replace the ACA. He wants to do a few things that are actually bipartisan in their support, like lower drug prices and surprise billing. And his relief, COVID-19 relief efforts have really focused more on letting the states decide what to do with the money. The problem now, of course, is they can't agree on an amount. And so I don't think that'll happen before the end of the year. But by contrast, if we do see a change in administration, if we do see a Joe Biden administration, what we'll see is the ACA be strengthened, unless it's cut down by the courts, which I'll talk about in a second. But his plan is to, of course, add a public option to the ACA and to lower the eligibility for Medicare to age 60, which would affect a lot of people in this country. And again, as I mentioned, he's also on board with some of these bipartisan ideas on drug pricing reform, eliminating surprise billing, and COVID-19 relief. I think you'd see a larger relief package if Democrats win, probably more relief for small businesses, including many of our clients, and probably something on the issue of COBRA subsidies, which you've covered in previous webinars, where people who've lost coverage because of this pandemic will be given a subsidy to help them pay for COBRA coverage to help bridge the gap, hopefully, to when their jobs come back. So what are our predictions? What's my prediction? I know Adam's going to ask me, so I was already prepared for that question. And look, I think this is not like 2016. I actually predicted in 2016 that Trump would win, which almost nobody else did. But this time, it just feels different. I think with the pandemic, the number of things going on, the polling looks really bad for him, even at the state level. National polls don't really matter so much. Remember that a lot of people have already voted, especially by mail. And so I think it all comes down to a state like Pennsylvania.
I voted like 10 times already, Brady.
I'm
just
sure,
so you know.
I hope it wasn't 10, but look, it's happening all across the country. And we've seen a recent Supreme Court case actually, or rather an emergency case they took yesterday saying that they would allow absentee ballots and mail-in ballots to be counted in Pennsylvania up until 8 p.m. on election day. I think that we could be in a situation where we don't know for a few days or maybe even a few weeks. But if I had to guess, I would say that Biden wins this election. We'll see if I'm right pretty soon. Next slide.
Brady, just a quick question, Brady, on that. Do you think it's going to be that night, or do you think it's going to be a few days after?
I think it might be in the early morning. Some people are saying landslide. I don't think so. Traditionally, polls tighten up in the last few weeks. We have a big debate coming up on Thursday on NBC, which apparently will include some mute buttons. We'll have to see how that goes. I think the polls will sort of shrink. His lead will shrink. And I think we may know in the early morning, if I had to guess, on November 4th. But who knows? I don't think it'll be a landslide, though. I'll say that.
You heard it here first, folks. You heard it here first.
Let's see if I'm right. So one other important thing I want to mention before we get into these case studies, it's about the Supreme Court confirmation hearings that happened a couple weeks ago. I'm sure many of you may have watched them, or Ron and I did a podcast on these a little bit more in detail. But this is important because this is a justice that will be added to the court, which will sway the balance of the court, a court which is hearing a number of many healthcare cases, including one on the Affordable Care Act itself. So a brief overview here of Judge Amy Coney Barrett. She was a professor at Notre Dame. She went to Notre Dame Law School. If she's confirmed, she'd be the only justice on the court who didn't go to an Ivy League school. So I guess there's some hope for me still on that point on the law schools. But her judicial philosophy is obviously conservative. She follows what's called originalism, what the Constitution originally meant. She, as I said, was a clerk for Justice Scalia, follows his positions. And on the ACA, when asked about her position, she gave the standard response about, I can't give you any previews or forecasts of how I'd rule. And so we're left with looking at her written opinions to see how she might rule in an ACA case. And when you look through her written publications and some decisions that she's rendered, it's clear that she's critical of the Chief Justice's decisions that have upheld Obamacare in the past. It looks like she says that she believes the decision that upheld the Obamacare case was stretched so far that it sort of is an impractical reading of the ACA itself. To me, that says that she's not a big fan of it, but I think the key to look for when we see her hear this case and how she may decide is severability. So I won't go over the whole case again because we've done that before many times, but we know that the individual mandate was zeroed out, right? The issue now in this case before the Supreme Court is whether the mandate can be severed from the rest of the ACA or if the whole thing has to fall. And based on my reading and having read a lot of articles about this, I would not be surprised if she finds the mandate unconstitutional, but actually saves the ACA. We'll have to wait and see what she does here. I think she's more of a long-term threat to the ACA. We'll have to see based on her decisions there. And again, just the impact of her being added to the court. This means that we'll have now a court with 6 of the 9 seats will lean conservative, right? She may decide a case involving Roe versus Wade and rights that have to do with that. I think she'll be deciding cases that will restrict access to certain coverage for women, especially for those employers that are religious-based. We've seen that happen already under the Trump administration. And finally, I think she could decide how this election turns out ultimately, right, if we do have a disputed election. So we'll have to wait and see there. But it's a big deal that she's being added to this court. It's the 3rd nomination for President Trump, and she will have a big impact on healthcare cases to come. And with that, I'll turn it over to Ron
Brady,
to kick us off.
So she,
Sure.
Brady, so she will be confirmed prior to the election. That's one. And then 2, if let's say Biden does win as you predict, will there be Supreme Court packing of justices?
Yeah, well, boy, I don't want to eat up too much of Ron's time, but I could go on for that for many minutes on that.
You
But I'll
got
just
30
say this.
seconds. I'm giving you 30 seconds, buddy. No worries.
Perfect, like a real interview. So she'll get voted on next Thursday. I think she'll go through before the election, like you said. I don't think ultimately that court packing will happen. I think it's being used more of as a threat, as something that they're hanging over the head of the Supreme Court. Say, hey, look, guys, if you start ruling ideologically, here's what we could do. That happened back, by the way, on the time of FDR, because the court packing plan was seen more then as a threat, and it sort of caused the justices to get serious and, try to preserve the integrity of the court. I don't think we'll see court packing. But again, don't hold me to it. And with that, we can turn it over to Ron.
Brady, if you're wrong, what are we going to do to you? When you say don't hold me to it, what's the penalty for being wrong here?
Yeah, what is that? Don't hold me to
hope,
it. I know. It's ridiculous.
I might be right, but I might be wrong. And that's 100% correct. Before I go ahead and get started, Adam, I don't know if you noticed Brady's comment about being still a possible candidate for the Supreme Court someday. I mean, I hope he's not talking about leaving because we need somebody to do the political update.
He clearly has been reviewing his own reviews of his own performance. So I don't know. That's fine. You know what, Ron? It's a good thing to have dreams, right? It's not a bad thing. Let him think it. That's good.
Well, before we talk about dreams, Adam, first let's talk about a couple nightmares. And there's a transition for you. We're going to go ahead and we're going to start talking a little bit about some actual case studies. And the format for these case studies are we're going to talk a little bit about some of the nightmare scenarios that we've encountered over the last 2 decades. And then we're going to talk about some of the services or things that could be done to avoid similar situations. Every case study that we're going to talk about right now is actually based on something that has happened. Some of the numbers, names, locations have been changed, but the actual underlying story or sort of elements of the story are true. Many of these were brought to us after the fact to see if there's anything that can be done. And unfortunately, in the case of many of these negative or nightmare stories, not much can be done once these things have happened. And one of the big ones, and this is actually something that happened that caused us to go back to the drawing board and actually create a service we'll talk about in a little bit, had to do with a rap network. And this was many years ago, but it's still stuck with us. You had a planned member who was on vacation. Back in the day when we used to travel, I don't know if anybody remembers those days, he was on vacation and he had an accident. And the accident was pretty severe. He had to be airlifted to an area hospital, and he was treated at the hospital. Now, as I mentioned, he was on vacation. He was outside the geographic area where his primary network was located. But both the air ambulance, which is very rare, especially these days, most air ambulances are out of network across the board. But both the air ambulance and hospital were included in the WRAP network. So not the primary PPO, but the WRAP network. Unfortunately, as it tends to be the case with some of these WRAP networks, the discount was a whopping 5%, which, if you know WRAP networks, is actually not that bad. I think we've seen some 3% and even 1.5%. So 5%, not too shabby. Unfortunately, the bills were $30,000 for the med flight and $285K for the hospital bill. Now, the plan, it's not on this slide, but the plan did not want to pay these bills with the 5% discount, and I don't blame them. However, what they discovered was that they, the employer that is, and the administrator had signed a contract. So regardless of what the plan document says, as far as how much is allowed, what's usual customary, they were bound by an independent, separate contract with the network and with the provider. So if they had not paid this amount, they would have been sued for breach of contract, not an appeal, not ERISA, a breach of contract. And so they were bound to pay. This is not unique to this situation. You hear this a lot with out-of-network claims, in-network claims, rat networks across the board having to do with, what's payable. But the bonus trick, or sort of to make this nightmare a double doozy, was the fact that stop loss, when they saw the claims, argued that they were, unlike the plan, not bound by the contract. So because this was a wrap network and it was a contract, they applied the terms of the plan document, which indicated that the payment would have been based on UNC rates, which, as you can imagine, they calculated to be much less than what was paid. So not only was the plan forced to pay it, but they were not covered by stop loss as well. So this is an example that, as we look at this case, this scenario has come up. I'd say it routinely comes up, this type of scenario, where a plan is bound to pay per a contract. The stop loss is not bound by the same contract, and you're basically stuck between a rock and a hard place. This happens, like I said, all the time. So what can we do about it? Next slide. So what we have started to help plans accomplish, and this is a response to this type of scenario, is what we're calling Unwrapped. This is a situation where instead of binding the plan with a contract, and again, you can have your traditional PPO for the area providers, but rather than bind yourself to pay providers outside that network with a contract, instead what these plans are doing, they're paying in accordance with the terms of the plan document, which we reviewed and updated. And so you had a plan, they had a PPO, but for anything not within that PPO, they were paying using a reference-based pricing approach, or Medicare Plus approach. And in this example, what happened, similar situation, you had somebody who was outside the network. Again, they were airlifted, so two very similar scenarios. This is actually a very recent case. The total balance was more than 61,000. The balance was 42 because the plan paid just under 20 using a Medicare Plus rate. And they did this, really, that was it for some time. It was almost a month later, if I remember correctly, maybe a month and a half, that the patient received a collections notice. So there was no appeal, there was no protest on the part of the provider to the plan. They went straight to collections with the patient. And the administrator with our assistance actually contacted the provider to try and get the matter resolved. They were not cooperative. What we ended up needing to do was assign it to our attorneys and escalate at the providers until we got the CFO on the phone. And what's interesting, some inside information, when we talked to the CFO, he basically explained that the people who are handling the balance billing, and I'm sure this doesn't come as a surprise to many people on the phone, they're not trained to deal with this. Basically, their job is to look at, here's the bill, here's what we got, here's the balance, get the balance. Why there's a balance, how the pricing occurred, who can you negotiate, how much wiggle room do you have to resolve the matter. Those are beyond those people's pay grade, and their goal is just, here's the balance, go get it. So we really have to go above and beyond those people. Go ahead.
Ron, don't forget, 99% of the time when a patient is involved in a balance bill issue, they have no representation. So, to add to what Ron said, at the end of the day, instead of utilizing a wrap network, as was discussed in the previous slide, if you treat these as unwrapped, meaning just put language in the plan design, tying it to a reference-based price or a Medicare Plus price, and then obviously on that small percentage of claims that are outside of your normal typical PPO or rental network, et cetera, those claims are paid at that rate. And then you build in an actual team of people that can handle any disputes, handle any noise, and then get sign off on those particular claims so that you can have significant savings on the overall claim experience. And we're talking about significant savings. We're talking about a situation where instead of getting 5% off, you're looking at 70, 80% off under the same scenario. Ron?
Yep. And just to wrap it up, Adam's point about having representation and people understanding how it works, you know, like I mentioned before, this plan had a PPO. Okay, they just didn't have a wrap, and this provider was outside that PPO. And you know, it's interesting because when you think about reference-based pricing or alternative pricing methodologies like reference-based pricing, most people think it's all or nothing, right? Either you don't have a network and you use RBP, or you do have a network and you can't use RBP at all. And when we eventually got to the CFO, and this is what kind of wraps it up, when we talked to the CFO, he said, oh, but, you know, you're breaching the contract. And the question, of course, was, well, what contract? What contract are we breaching? Oh, your network contract. There's a logo on the card. We said, well, did you happen to notice that logo and that network is restricted to a certain geographic area? Oh, yeah, well, what about the wrap? There is no wrap. And so they were working off of an assumption that if you have a PPO, you must also have those multi-layered networks with the wrap. This one didn't. Once he realized his error, they were willing to negotiate, and we got it resolved. So that's the point. It's not an all or nothing approach. It's more of a spectrum of options from all to nothing. And there's plenty of middle ground for people who are willing to dip a toe into it. So next slide.
All right. Thanks, Ron. So continuing our political update, this one's relevant here because, as Ron mentioned, in a lot of these Unwrapped cases, you're facing really high claims from things like air ambulance. And so we wanted to give you an update on what's going on politically with air ambulance. Is there government action in this area? And I would say that the same way that insulin has been sort of the catalyst for reform in drug pricing, air ambulance has been a catalyst for reform in surprise billing, because it really is a case where you have sticker shock. And it's no use if Congress solves the issue of hospital billing if we're bankrupting people on the way to the hospital. And so, look, according to this report from last year, about 70% of air ambulance services are out of network. The median price, $36,000 for helicopter transport, $40,000 for fixed wing transport. Those are extremely high prices. And look, from the air ambulance provider perspective, what they say when you ask them why their prices are so high is they say that most people they deal with are rural and are on Medicare, and the reimbursement rate for Medicare is tremendously low. And they say their costs are extraordinarily high, and they're not entirely wrong, right? But the problem is that these people are not a network, that they're hard to negotiate with, and that at the moment, your immediate concern, if you're a patient or if you're a family member, is getting life-saving treatment, right, to your loved ones. So you're not thinking about the cost of this care at the moment. So what's going on now behind the scenes in Congress, it's very slow, but both the House and the Senate have different bills that they've worked on to try and resolve more broadly the issue of surprise medical billing. But in some cases, in more of the subcommittee level, there's a more of a narrow focus on air ambulance. And they're looking at things like, can they use some kind of arbitration process to resolve this issue? How can they get help to the uninsured who may be paying cash in these cases? I think we'll see more progress next year on this stuff. I mean, we've been talking about surprise billing for a couple of years now. Unfortunately, because of the pandemic, it's sort of gotten sidelined. But just know that when this issue does come back to the forefront, what I think we'll see is this is one of the top things at the top of the list in terms of what Congress may deal with going forward. Let's go to the next slide. All right, so keeping on the theme here of case studies, I want to talk about a couple that have to do with stop loss and COVID-19. You may not think these two things are related, but it turns out they actually can be. So this case is one we got where you'll see the stop loss denial had really nothing to do with the patient's COVID-19 status. It had everything to do with disclosure issues. So here we had an inpatient stay for COVID-19, a lengthy one, which resulted in over $1 million in claims. We've seen a couple of these. There's far more of them being discussed in the news of people that have just had really extensive hospital stays involving the ICU and expensive equipment. Here, the plan paid the full bill minus a generous 30% PPO discount. And they subsequently went to stop loss and said, hey, we went over, here's our $700,000 reimbursement request, which is the bill charge minus a 30% discount. And turns out, to their surprise, the claims were denied. The claims were not denied, at least not primarily denied, for a reason you may expect, experimental investigational, not medically necessary. It turns out that the patient, unfortunately in this case, had a very high-risk condition that the plan sponsor had failed to disclose to stop loss. And so when the carrier realized that this person was not disclosed on the disclosure form, they denied all the claims associated with disclosure. And it gets pretty complicated, but these situations happen far too often And they happen really in one of two cases. One is where the condition that a person has was present and not disclosed when you're binding new stop loss coverage. And the other is that while coverage is ongoing, someone develops these catastrophic situations and they incur expensive claims, and those aren't disclosed timely. I would say the more surprising situation for someone, and one that I think we see more often, is where coverage is being bound initially and disclosure is not properly made. And that can happen pretty often and pretty frequently if you're not paying attention or reading carefully what the stop loss policy says. So one thing to note is that stop loss policies have a provision in them called entire contract provision, which ties together all the parts of a stop loss policy. So everything from the policy itself, the application, and the disclosure form. This is literally a separate form, mostly, usually, right, from the stop loss policy itself. And in that form, you'll see the lengthy language about all the things that have to be disclosed. Sometimes they'll use certain trigger diagnoses on a list. Sometimes you'll see a certain dollar threshold of claims. That's for the ongoing sort of thing. But when you're binding coverage, you've got to make sure that you're disclosing all known risks. That's how it's phrased, all known risks. Now, that's also where you see a source of dispute, because what is a known risk, right? What's reasonable for the employer to know of? And the cases that we see where employers get in trouble is that usually involves a dependent, where there aren't the typical triggers that the employer would see, like a leave of absence, right? And they wouldn't necessarily know what's going on. And when you combine that in a case which we've seen, where you have someone incurring high dollar claims which are denied and not being reported to the stop loss carrier, that's a recipe for disaster on renewal. So the takeaways are: read the disclosure statement, be careful about what it says, know what has to be disclosed. Are they using words like known risk, potential risk, reasonable risk? If you don't have that statement, make sure you get it, because odds are you've agreed to it, even if you don't actually have it, because of that provision I referenced earlier about entire contract. And then secondly, but probably as importantly, is understand who is handling your reporting. When employers secure stop loss coverage, they're not the experts here. They don't know what they need to send in. This is typically handled by a TPA, but sometimes it's handled by a broker or another agent of the plan. And when you're getting everything together to apply for stop loss coverage and you submit all the information over, if you forget something, if you leave something out, then you're going to have a big problem later on down the road, like this plan had when their member unfortunately came down with COVID-19 and had an earlier existing condition which should have been disclosed. And so what you need to do, if you are a TPA, understand your obligations. Are you reporting properly to the stop loss carrier? Is it your obligation to do so? If it's not, do you know whose obligation it is? We've seen cases where certain TPAs and some ASOs have a process by which they do not report denied claims. They only report claims that were actually paid and approved. And the denied claims are actually the exact claims that should have been given over to the stop loss carrier. And the carrier comes back and says, look, we don't care that your process is not to give us denied claims. We want all the claims that you should have known about, right, that disclose a risk. And so that happens far too often. It's an avoidable mistake, and it can be extremely costly. And speaking of extremely costly, I'll turn it over to Ron for the next case study.
I don't know what you mean by that, but no, it's funny because Brady, you're talking about when you're required to disclose, and I'll give full credit. I mean, I tease him all the time, but I'll give full credit to Adam on this one. Over the last 20 years, one of the sort of the mascot names that I've wanted to give him in the past is Disclosure Dan. And the reason for that is, even when you're not required to advise your stop loss about a thing that you become aware of, it may still be worthwhile to do so.
Just do it.
Do it.
Makes sense.
Because here's the thing, and one of the services that we've been providing, and that's what's appearing now on your screen, is claim negotiation and sign-off for CNS, where these large dollar claims come to the Phia Group pre-payment. So before the claims are paid, whether we're talking about CNS or subrogation or balance billing, anytime the claim is either large or has the potential to get big, one of the first things Adam always says is, did you tell stop loss? Did we contact stop loss? Did we work with stop loss?
I actually say, the first thing I say is, who's the stop loss carrier? And when you realize that the people that sent over the case don't even know who the carrier is, then you know you got a problem. So you're right. The number one thing is just disclosure. Get everyone on the phone, write an email to everyone, make sure everyone's on the same page in relation to what your strategy is going to be. Simple.
I can tell you, and maybe it's human nature, maybe it's just a business, who knows, but you look at a scenario like the one before you, where we had a claim or a grouping of claims that exceeded $1 million. And it was prepayment. It comes in. We communicated with stop loss, got everybody on the same page before we even engaged the provider in negotiations. And by doing so, we were given rope to play with. And we managed to execute and secure an excellent discount in this case, and everybody was happy. But by getting everybody on the same page ahead of time, we got a lot of wiggle room. I got to tell you, there have been situations where the claim's already been paid. We're trying to negotiate a balance. Maybe the entire thing's been paid, and now they're trying to get an overpayment back. And at that point, because the cat's already out of the bag, you know, the stop loss carrier, for whatever reason, they're less flexible. They're less willing to sort of throw a couple chips into the center of the table because ultimately, from their perspective, you've already paid too much. You know, they don't really have an obligation to pay. But if this takes place prepayment, you're basically saying, hey, look, I'm not putting stop loss in a situation where I've already paid and now I'm coming after you for payment, stop loss. Instead, it's, hey, I'm looking to go and fight the good fight. And if I win and I'm victorious, not only do I benefit, but you benefit as well. So will you give me something now to provide ammunition and allow me to go in confidently and fight this bill? So it seems basic, but if everybody's on the same page ahead of time and you work out a strategy ahead of time, the results are usually much, much better. So
That's
take
right,
the
Ron.
last two slides, put them together, and understand what lessons it teaches.
Ron, before we move on, the key thing is when you set up anytime you want to work with any vendor or even your own internal team, it is very important, and Ron alluded to this, even if the claim isn't a large dollar claim or in your mind isn't a large dollar claim, you need to know what the specific deductible is for each one of your plans. So if that claim is getting closer to that spec, you already have had contact with the carrier to make sure you're on the same page. So great points, and I guess we'll turn it back over on the political update. Is that right? There you go, Brady.
Let's go, Brady.
Thanks. Well, look, we've talked about how a few of these COVID-19 cases can surge into the $1 million range. One thing to note is that after this is all over, by the way, you can bet that COVID-19 is going to be considered a pre-existing condition. And so I wanted to give a quick update on an executive order that the president issued a couple of weeks ago on pre-existing conditions to see what exactly it really means here. The takeaway is this. There is no comprehensive health care plan from the Republican Party. That's, I think, one of the reasons why the president's suffering in the polls, by the way. But what he has done is issued an executive order saying it's the policy of the United States to give Americans seeking health care the guarantee that we will cover you with pre-existing conditions. I want everyone out there to understand that what that really means is nothing. It has no enforcement power. It's an executive order. It's not legislation. And that the takeaway here is that if the ACA is repealed without a replacement, then those protections for people with pre-existing conditions go with it. And that means that if and when other things are added to that pre-existing condition list, like COVID-19, then you can bet that insurers and plans will look for ways to limit coverage there. And that's just the takeaway there, that these executive orders don't really do much on their own. What we need is a comprehensive plan to replace it if it is tossed out. And for that, I'll turn it over to Kelly to talk about another political update.
All right, so a topic that's hot on the market right now is this concept of federal guidance being issued on Canadian drug importation. Probably the main question being asked is, what does this mean for the self-funded health plans? And unfortunately, the answer is for private self-funded health plans, not a whole lot. This rule that was issued right now is focused on a specific segment of individuals and companies that are talking about these importation programs. So it's focused on states, Indian tribes, or in other circumstances, pharmacists or wholesale distributors. There's a lot of different requirements and restrictions that are included in this, and there's only a couple of them here that are listed on the slide. But a couple of the crucial ones are that it's limited to a supply chain that includes only 3 entities. So the manufacturer, the foreign seller, and the importer. So that's kind of crucial. It's also has to be approved by Canada's Health and Canada's Products and Food Branch. So that's super fun. And then it also plays into the conditions of the fact that otherwise it still has to comply with the FDA approved new drug application process. So in addition to all these, there's also record keeping requirements and label requirements similar to those that exist today. And there's specific rules that when it comes into the specific ports that are designated for points of entry, that there's time there where things have to be retested and relabeled. So it's going to be a very intensive process, unfortunately. And, you know, there's definitely probably more to come on this. Like Brady has talked about, this isn't the end of the concept and discussions of drug importation and drugs overall, as they play a crucial part in this election process. So
guys, the bottom line is what our claims data is showing us too is the number of people on prescription medication has skyrocketed since COVID started. So if we already had a problem before COVID as it relates to drugs prices, et cetera, not just on the, you know, on those rare high risk claims, you know, we're talking about your everyday normal situation where people are on, you know, antidepressants, whatever it might be. But we're seeing a huge increase in the number of people on drugs for whatever reason. And clearly something needs to be done to deal with the cost curve, because if not, we're just going to see this thing spiral even greater. So.
Yeah, and while we are on the topic of specialty drugs and the drug topic, that transitions us into the next case study that we have, which is a claim appeal trick. So something to watch out for. So in this situation that came up, a plan had received claims for a experimental chemotherapy drug which cost $250,000. The TPA's medical management team reviewed the treatment plan and determined that the charges were experimental and investigational and therefore not covered. So the TPA consulted with the plan. The plan subsequently denied the claims. The member, of course, then appealed. The denial was upheld, so then the member sought, you know, external review under the ACA rules. So the IRO then gets this case to review, and they recommended overturning the previous denials made by the plan, specifically because they concluded that the drug was medically appropriate and medically necessary to treat the condition. But there was nothing in the report that talked about whether or not the actual drug was experimental and investigational. So there were a lot of questions that report led to and had a lot of, you know, unclear information in it. So the plan and TPA at that point.
Kelly, question. So you're telling me the plan denied it because of E&I, but then when it went to a medical reviewer, an external one, they didn't even answer that question. They just said it was medically necessary.
Right. That's a real head scratcher,
Yep.
huh?
Right. I mean, and that's why, folks, it's very important. Even though oftentimes we see people try to hire the cheapest medical review company out there, right? Sometimes it's important to not just go with the low cost, but actually have someone that is reviewing what needs to be reviewed and answers the questions that need to be answered. Because like in this case, it didn't help.
Right. So the plan, when they got the direction from the IRO, the plan paid the claim. But then when the claim went to stop loss for reimbursement, it was denied because the drug was still experimental and investigational. So important kind of takeaways from this one specifically are that the ERISA plans and administrators do have that right to judicial recourse under the IRO situations like participants do. So they can still find themselves in court if the decision doesn't necessarily come down the way they want it to. But, you know, we don't really have anything, unfortunately, in all of our research. We were unable to find what kind of, in our lovely legal terms, how much deference the court would give to the IRO's determination upon review. So it's just, you know, what would the court say regarding the IRO's review versus these situations at hand. So it's just how much deference they would give. But the argument in this case is the fact that, you know, the plan clearly excluded experimental investigational drugs. It obviously covers things that are medically necessary, but not if they're experimental investigational. So, and it's important to note that the TPA did actually send the documents and the plan document and whatnot to the IRO. It's just that the question didn't get presented. So aside from litigation, there's a couple other opportunities for this one. And I don't know if you want to go back a slide, but there's a couple other opportunities for what could have happened on this one. That the plan could have contacted the IRO if they believed there was an error and tried to discuss with the IRO the processes and procedures and how they came to that conclusion and ask for review. They could also look to the contract they have with the IRO and see if there's any other recourse. If the plan believes that there was an error that occurred, if there's an indemnification process or other arbitration process, those will be crucial to look for. Another interesting option is that the stop loss carrier could potentially add into their processes the requirement to look at the IRO questions, the questions that are being presented. But this would be somewhere to tread lightly, because the stop loss carrier can't be seen as interfering with the process. So there's going to be, things to balance there and kind of tread lightly with that specific piece. But it's definitely something that should be considered. The plan could obviously, like Adam said, pick another IRO for future review. If they don't want to go back to the same IRO, they could contract with another one in addition to the other couple that have to be contracted with. And then there's also the potential to, look at the ERIC accreditation for the IRO if there was something in it that signals that there was an abusive process. So there's a lot of options with this one. There's a lot of different considerations as to how to better remedy this. But, definitely ask questions as soon as they come up, because once things come to us after the fact, there's sometimes there's not a whole lot that can be done. But hopefully this will be a good takeaway. And with that, I will turn it over to Brady.
Thanks, Kelly. Yeah, just quickly on this case study, it's an example similar to the one Kelly just went over. The difference here is this happens before the IRO process. The takeaway here is that make sure you're asking the correct questions of the medical review company. It's not just about how good they are. That's very important, as Adam said. But it's also important to make sure you're asking the right questions. Some of these cases are very, very important, and it sometimes does take an attorney to actually pose the right questions to the medical review company. Because if you don't get the right questions asked, you'll get answers that are confusing, that are misleading, and those will be relied on by the plan, and the plan could find itself in a whole world of trouble if stop loss does not agree and does not reimburse. And so if you have questions on that, you can send them over to us. We'll be happy to help review the questions that are being sent to medical review companies and make sure you're getting the result and the question asked and answered the way that it needs to be asked. Back over to Kelly.
Thanks, Brady. So for this one's not nearly as complex. There's not a lot of considerations other than start asking questions up front. So that's kind of the key takeaway here. But in this situation, with this trick that happened, is that a plan is not a grandfather plan with an employee that's active, received an unfortunate terminal diagnosis. The employee was able to locate an experimental drug that came with a sticker price of $3 million. And the employer wanted to cover it with a cap, of course. But they did so without talking to anybody first. So the plan decided to cover the treatment with a cap. They determined that the treatment was not an essential health benefit, so they applied that dollar limit. However, when it came to the participant, obviously there was a big balance bill with the sticker price because they didn't pay the full amount. Of course, then subsequently when the claim hit stop loss raised objections and they did not reimburse the expense. So a couple key takeaways here is that paying things outside the terms of the plan is never really a great idea. There's definitely ways to take care of your employees that can happen outside of the plan. That there's definitely considerations like the fact that reimbursement could potentially be taxable, but that's kind of the pros and cons that employers have to look at when they're trying to take care of their employees, because you obviously want to make sure that the plan stays financially solvent. And by paying something outside the terms of the plan, you're potentially opening yourself up to a breach of fiduciary duty, which, they can be spotted potentially by a participant or somebody else, a complaint to the Department of Labor, which could trigger a DOL audit. So this one is a little bit scary because there's a lot of implications that could add up very quickly. But the long and short of it is if they had talked to a consultant up front, if they could come to us and ask us these questions, we could have potentially looked at the options and weighed all the different pieces of it to decide what was the best course of action and how to take care of the plan while also taking care of the employee.
Hey, Kelly, I just hope that they fire their broker, because that's all I got to say on that.
Not a great one. So with that, I'll turn it over to Brady for a little bit more of a political update.
A quick update here on people. We've got a lot of questions about remdesivir and Regeneron, the treatments that the president himself took when he spent 3 days in the hospital recovering from coronavirus. One thing to note here is that this level of care would be probably far out of reach of the average plan participant, in excess of $300,000. I saw a case today study saying it could have been $650,000 in cost when you include all the transportation that he had. But look, there's a difference between two terms to be aware of in terms of the drugs that President Trump received. One is compassionate use and one is emergency use. The takeaway is that if a drug is approved for compassionate use, it is not technically FDA approved. That's exactly why the president got access to his Regeneron cocktail of steroids and other experimental antibodies. That drug would almost certainly not be covered by self-funded health plans. If a drug, however, is approved for emergency use or expanded use, that's different. And most self-funded health plans, if they have the proper language, would consider those drugs covered. But just know that the one the president took is not under that list. It falls under compassionate use, and there's a difference there. Be careful about which classification the drug falls under when you're going forward. And with that, I'll turn it over to Ron.
Sure. So before I go ahead and jump into this, and you know I've got a passion for subro, so subrogation coming up. But one last word to the wise as far as those IRO questions were concerned. Don't let the provider dictate the question. You know, you could deny a claim for E&I, and then the provider can write back a 10-page letter as to why this was medically necessary to save the person's life. That was not the issue. It was E&I was the issue. So don't let the provider set the tone or ask the question for you. Looking at subrogation real quick, this is an example where somebody, in this case it was an ASO, they were doing this in-house, somebody was diagnosed with non-Hodgkin's lymphoma. Now, little did you know that for the span of 30 years, 10 years prior, this person was constantly exposed to a herbicide, right? Well, there's a class action regarding a herbicide, and little did they know that the non-Hodgkin's lymphoma was caused by the herbicide, and they could have jumped in on that class action and subrogated and recovered some money. So again, this is just an example where just because it's not a car accident or a work injury doesn't mean that there isn't a recovery opportunity. Next slide. So speaking of class actions and recalls and things like that, you know, sometimes it's very complicated or difficult, right? We could talk a little bit about a subrogation case that came up that related to a recall as well. We had a patient who incurred multiple claims, both for the hip and the knee. There was a recall on the hip, but not on the knee. And as a result of this case, basically what the liable third party said was, we'll pay for the damages caused by the hip, but not the knee. But a little investigation and some digging reveals, the knee injury was either caused or, in this case, exasperated by exaggerated or the severity increased due to the issues from the hip. And without taking you to law school, there's this rule called the eggshell skull rule, which is basically where you take your victim as you find them. If you have a car accident with someone who has a very hard head and they don't suffer any injuries, you're lucky. If you have a car accident with someone who's got an eggshell skull and you cause severe injuries, not so lucky. So again, this is a situation where you had an individual who suffered a loss due to your liability, and their damages were severe because of a pre-existing issue or condition. So again, recognizing opportunities to recover money in unusual situations like recalls and class actions and toxic torts is one thing we need to make sure we're doing. And the second thing is make sure you're identifying every possible issue, injury, etc. that's related to the thing about which the case is orbiting or centered upon. Next case. So here we have a situation, balance bill, classic situation. You have the plan, they paid the RBP amount, patient was balance billed, the plan made an effort, couldn't get it resolved, said, that is the way it is. We'll let the provider and the patient duke it out. Patient gets an attorney, the plan is all excited, thinks, all right, they're going to sue the provider, and they sued the plan. Ouch, not so good. So what is this is sort of teaching us? Well, one, make a better effort to resolve it, but two, make sure that the individual plan members, their families, the people who are affected by this are educated and understand the way reference-based pricing works so that even if they're angry at you, they know that you didn't do anything wrong. It's all about setting the tone ahead of time. Next one, Brady, you got about a minute.
Yeah, so the takeaway on this one is that a lot of collections attorneys don't actually expect you to show up to court. In this case, a patient had a large balance bill. Some of the claims involved infections that were the provider's fault. Basically, they came to us for help because the provider would not settle, would not take anything less than 100%. And once we referred the member to legal counsel and he appeared in court, the collections attorney was floored by that, very surprised, and advised the client to accept the settlement, which they did. The plan only ended up paying 20% more of Medicare for the eligible claims. The takeaway is if you go to court and surprise them when they're not expecting it, they'll often back down.
And with that, we are done, ladies and gentlemen. Thank you once again for joining us. Regardless of what you're going to be doing for Halloween, I hope you have a good time with that thing. Hey, by the way, also, be sure to join us for our November webinar. You'll be very thankful that we're doing yet another free webinar. Of course, between now and then, we welcome feedback. Anyone who has any particular issue, concern, question about which they would like us to talk and cover in our next webinar, go ahead and submit it, and we will be sure to add only the coolest submissions to the next webinar. But on behalf of myself and the entire team, thank you so much. Continue to be well, and we'll talk to you in November.